Hey guys, as fun as it sounds, I know we're going to do a quick contract class talking about the new contract, which was established June of 2025. So if you're watching this, this is all about the new contract for you guys. Um, let's get started. I want to make sure that this is kind of like an overview of the entire contract. Some of you are going to roll your eyes and say you don't need to go through all of these lines, but this is for agents who maybe need like a quick brush up on the contract. So we're going to go through every line. However, if you are just interested in one particular spot of the contract, this entire training video will be indexed so that you can just click on the time that it starts for a particular section that you're interested in. So we're going to like jump right into it. Okay, uh, looking at the contract, this is the Form 310. This is the agreement to buy and sell real estate for residential only. There are several other versions for condos and vacant land and all that. So just make sure you understand that there are separate contracts to submit offers on for different types of real estate. This one is for residential. In the first section, we're going to talk about parties. In the first two lines is for you to spell out what the buyer's names are. Who's going to be in this contract? If it's a father, daughter, and they're both going to be on the contract, make sure they're both listed on the top line under buyers here. As far as sellers go, pull up the tax records on MLS, find out what the seller's full names are, place that in the seller line, which is the third line, third blank line that you see here. Then we go into definitions about what each definition really means throughout the entire contract. Party, as you know, is either a buyer or a seller, or parties means both. Brokers, the broker in charge, their associated real estate licensees. Subagents doesn't really count because we don't allow subagency here. Um, so when it says brokers, it could be myself or it could be you guys. Closing attorney, who's the closing attorney going to be? You guys are like, well, I don't know. I'm submitting the offer. Most of you guys know what closing attorney you're going to be using. So just make sure you put in the closing attorney's name here. And we will also put that name in another place in the contract when we get there. So there is your closing attorney. Who's it going to be? Weeks Law Firm, Fody Law Firm, Hand Law Firm. You guys get the point. Just write who the closing attorney is going to be. D is effective date. I want to discuss this because a lot of you guys aren't paying attention to the full definition of effective dates. According to the contract, effective date is the final date upon which a party to negotiation places the final and required signatures and or initials and date. You guys have got to initial and date any changes. Anytime there's an initial, there needs to be a date. The auditor has come out with about 16 pages for their little checklist for everything they're going to be checking during our audit season coming up in a few weeks. And initials and dates are being drilled into our brain. So I fully expect to see something come across our desk as far as a fine is concerned because not everybody is dating and initialing every little portion. Remember, date, initial. Please, it's on the contract. Going into E, which is good funds. Is the transfer of funds required for any required time frame. In other words, earnest money. F, time. All time shall be South Carolina local time, so not their time, nobody else's time, South Carolina time. Time is of the essence in respect to the provisions of this contract. Make sure your clients know what the deadlines are for each and every little thing that's required. I have found that a lot of agents like to go and once their buyers are ratified or sellers, either one, once they're ratified, they say, congratulations, here's a copy of the ratified contract. Here's an outline of all the important dates you guys must know. And then for me, just drafting up all of the required times, like, on July 18th, we got to make sure that you understand the due diligence is ended. So we've got to have all of our inspections done. Finance contingency ends on this day. This day is when the CL 100 will be due. This day is when we need to submit repair requests. All of these things, if you just draft up an email and kind of keep your clients in the loop, it is a great standard of practice for you guys to get in the habit of. All right, next section. The buyer or seller is a South Carolina real estate licensee. If the seller is a real estate agent or the buyer is a real estate agent, we must mark this block. Also, next section Initials. The buyer initials in this section here. The buyer's initial here. I'll get there. Follow my highlights. The buyer initials here. Do not forget, are they a customer or are they a client block? That is going to be another highly audited issue. Did you mark client or did you mark customer? And do we have paperwork to reflect the agency? So do not skip this block. Everybody skips this block. Make sure you mark which one they are. Same with the seller. The seller acknowledges they've received the brokerage relationship form. Are they a client or are they a customer? Which one did they choose? It's very important that you guys have that on there. Now, item 2 is we're talking about purchase price. What is the purchase price going to be? In this block, you need to write it 2 separate ways. The first way is the written numeric offer that you're submitting, and beside that, the long form. We just like to have both. Our attorneys are very picky about that. It's a lot of old school style, but it's starting to make a comeback because a lot of people are changing numbers at the last minute, and they just don't want to have that availability to where you can like make a 7, a 8. So numeric form and long form preferably. Just keep an eye out for that. Underneath purchase price, we're going to talk about payable by transfer of good funds, again, money, whether it be finance, a combination of finance, or just cash. A rule of thumb, if you're watching this as a contract review, just to brush up, even if your clients are paying cash, unless we are in an insanely competitive market, then even if your client is paying cash, I have always recommended that you do a combination of finance and cash in your offer. I never just say fully cash because your client who may be paying cash may still need a loophole to get out. For me, the combination of finance and cash is always a great loophole, just so that we can. Plus, a lot of cash buyers always say, well, I was going to spend all my cash, but I really want to kind of keep some liquid assets behind. So I'm going to finance a little portion of it. It's always good just to cover your bases with that. The next line is verification of cash available for closing is attached or not attached, or the attachment will be delivered by. Again, are you doing the bank statements to the listing agent? If so, you can attach it, or you can wait to see if the offer is submitted before we submit the verification of funds. The next line is that this contract is or is not contingent on a home to sell. So do your buyers have to sell their home before they can buy this home? This is where you would mark that. And then you would also attach the 504, which is the buyer sale contingency addendum, which has been updated as well as far as June 2025 goes, but that will be in a whole separate video because this is long enough, I'm sure. All right, item 3, we're going to talk about property. Not much has changed in here. It just talks about the seller will convey the property, the buyer will purchase it for purchase price, to include the land, the improvements, the landscape. It does say that the seller agrees to maintain in operable condition the home, and any personal property that has been listed will also remain in operable condition, to include any landscaping grounds, subject to wear and tear. It does say that hold on, I'll get there. I got to highlight it. I get lost in my own contract too. It does say that the buyer acknowledges the opportunity to inquire about homeowner associations, common area issues, any easements, any things like that during the contract time, preferably during due diligence. So just note that it does say that things have to be stayed in really great condition up until closing. Wear and tear is going to be normal, and that the client has the ability to ask about all of these things prior to submitting a contract. The next little section there, it's going to be the address of the property that you're submitting an offer on, to include the city, the zip code. All of this you can get from MLS tax records. Put in as much information as possible. It makes it easier for the closing attorney to include the tax map ID number right here. Now, the next section right there says parties agree that no personal property will transfer as a part of the sale except what is described below. In this section, a lot of people put refrigerators, stoves, don't ask, yes, and do not say per MLS either. It has to be spelled out, every item that your client wants to make sure conveys with the property. So you're going to put refrigerator, a washer and dryer if they want that, the stove, any blinds in the home, if it's pre-owned, window treatments, and if your client wants the storage sheds in the back. Listen, there is an argument when it comes to storage sheds that if they are on skids, they can be easily moved. They do not require tearing up the property. So that is a personal property item, not a fixture. Yes, I know. Sometimes these storage sheds are built on frames and bolted into the ground with footers. You couldn't remove that, but you'd be surprised what people remove. So if there's anything that your client is very adamant about or mentions it, or as you're getting ready to write this off, or make sure you go through the items that were in the home in your head that would maybe be considered personal property, enlist it in this section right here. Okay, right underneath where you put in the address. All right, moving on to item 4, conveyance, possession, or closing. This is closing. This is when your clients want to close. Please note that the contract says that the closing will occur no later than 5 p.m. on or before this date that you write right here, which is the closing date. It could be on or before. It cannot be after. But let's just say you have a closing scheduled for July 10th. Yes, you can move it up to July 3rd if the lender has agreed and approved that change. You don't need to make an adjustment to the contract because the contract says on or before. So you're good either way with that. Another section that is, excuse me, that is highly skipped over is this section right here, right there where that blank's at. And what that section is the seller is agreeing to provide a marketable title with the conveyance of this property in a recorded general warranty deed free of encumbrances. And this is exactly where you're going to put the name of who the property is going to be deeded to. So remember at the top we said if a father and daughter are submitting the offer, but the dad will have the mortgage but wants to put the property in his daughter's name, this is where the daughter would go. But if the dad wants to be on the deed, which I don't imagine he wouldn't want to be, then you put dad and daughter's name in here so that they can make sure that the deed is written into their name. Do not mess this up. Do not skip this. Make sure you put who is the property going to be deeded into. It discusses that the deed shall be delivered to the attorney's designated place on or before the closing date. Again, the attorneys usually do all this stuff. Seller agrees to pay all recording fees. Parties agree broker shall have access to closing relevant documents. Broker shall be given copies of settlement statements prior to closing for review. Parties agree to use and hire a licensed attorney. The seller shall convey a possession of vacant and reasonably clean property free of debris. Tell them, get your junk out of my damn house. Don't let anybody sell property that's covered in junk in their garage. Along with all the keys should be conveyed and brought to closing, remote controls, available documents, etc. So it just goes into all the things that your buyer can expect the seller to bring for closing. All right, earnest money. Next section. Earnest money, total of blank percent. What is the total amount of earnest money that your clients are going to put down? Goes in the first blank. And the second blank says it'll be paid as follows. Blank dollars will accompany this offer. That's all you need to know. Do not fill out that other half. You're not paying additional earnest money at a later date. There's a caveat to that, which we'll get into later. But right now, remember, earnest money is due at the time of submitting the offer. So you're going to say $3,500 will accompany this offer. $3,500 total, $3,500 will accompany. That's it. Now, in this section here, you're going to put NA, this blank right here, NA, and then the date will be NA. And the earnest money is in the form of what? Is it a check, cash, or other? Make sure you put probably check or wire. We've had a lot of wires lately for closing attorneys. Blank to be a credit to the buyer at closing. Wire, other, any other way. There would be no other way, just a wire. It'll be distributed only as parties agree to in writing or by a court order. So a release of contract. Remember, termination fee is related to due diligence. The release of contract is related to earnest money. So if you've got both termination fee you're paying out and you want your earnest money back, which the attorney's holding, you will need both a notice of termination and a release of contract to get the earnest money back. A lot of people are forgetting that. I actually had an agent who's like, I've already submitted the termination fee. I've already submitted the notice of termination. The listing agent's asking me if I submitted the earnest money and we're out of contract. So why is she asking me that? She's asking you if you submitted the earnest money so that y'all can submit a release of contract to get the earnest money back. So don't forget about those things. Those are two totally separate animals. Make sure you understand. Notice of termination, termination fee, release of contract, earnest money. Okay? Two of them. All right. That was a long story, but it's just like a little pet peeve of mine. The buyer and seller authorize blank as the escrow agent. Who's holding the earnest money? Well, at Carolina Elite Real Estate, we don't hold earnest money. The closing attorneys do. So do you remember when you put the closing attorney on the top of the first page of the contract? You will now put that same closing attorney right here in this section as to being the escrow agent. It will be Weeks Law Firm, Fody Law Firm, Hand Law Firm. You get the point. Any attorney that will be holding your earnest money, your client's earnest money, will be going into this blank right here. Okay. One section I want to mention is if earnest money is not delivered by the upon date, by the blah blah blah. It's Monday after 4th of July weekend. Bear with me. If earnest money is not delivered by the agreed upon date above, the seller may terminate the contract by delivering notice of termination to the buyer. So if the attorney says, I have not received the earnest money yet, and it's been 24, 48 hours, go ahead and submit the notice of termination. That comes into play when the market gets a little hotter for everybody, so just be aware that that actually does exist. The next section talks about if the earnest money is being held by the real estate brokerage firm or if it's being held by the law firm. Again, it's just saying that, hey, listen, buyer and seller, we cannot release earnest money until we have a release of contract or a court order. That's just the way it is. So that way they can't say, give me my earnest money back. All right. The most controversial section of the contract has now become a little bit easier. I mean, literally, we could not write this contract to spell it out for everybody. And I guess you can look at it two ways. Did they over-explain this portion because people weren't getting it? Or did they over-explain this section so that the agents who do understand it have written proof on what they're saying is real? I'm not sure. I'm kind of 50-50 on that. So as you know, we have beat this section to death. It's 6A4. This is the portion that we talk about transaction costs. The first section discusses that, let's scroll down here, right here, that the buyer will pay buyer transaction costs and the seller will pay seller transaction costs. This is like, hey, everybody, if nothing else is done, this is the bottom line. Everybody's responsible for their own fees. Number one talks about buyer transaction costs and what's feasibly included in the buyer cost, okay? To include the amount owed of compensation the buyer owes to their broker. Also, the cost of any inspector, appraiser, or survey. So, item 1 explains all of the buyer's transaction costs. Item 2 literally explains all of the seller's transaction costs to include their required real estate broker compensation that they have an agreement for. So everybody pays their own fees. That's what number 1 and number 2 say. Number 3 takes a few items that are always kind of questionable and allows the agents to designate who's going to pay these fees. So these fees are homeowners association, printing or document fees that are requested by the HOA, any fees for a certificate of assessment, capital contributions, any public or private transfer fees. All of these really weird things that buyers and sellers don't realize until closing. Section 3 allows us to go through and say who's going to pay it. So right here on the top of section 3, is it going to be a seller or is it going to be a buyer fee for A, B, and C down here? So who's paying? buyer or seller, these three section of fees. Now, the one thing you will see that's not listed on here that can be considered questionable will be like HOA assessment fees. So who's paying the HOA fees that are due for the year? It will go under item, I think it's 21. I think we get there in a minute, but one of the adjustment sections later in the contract, it will say that the seller will adjust it just like taxes. So although the HOA assessment fee, annual assessment fee, is not listed on A, B, or C of item 3, don't worry about it. We talk about it when it gets assessed in item 21 or 22. I think it's 21. All right, now to follow along, we're on 6A4. See? 6A4. This is the fun one. Now, it says 4. At closing, the seller will pay buyer's transaction costs not to exceed X amount of dollars, which will include allowable and non-allowables first, and then allowable FHA and VA. This amount should not include any funds that have been, listen, I wish I could underline this myself. This amount that you're requesting the sellers to pay on the buyer's transaction costs does not include any fees that y'all have already negotiated in the compensation agreement. The compensation agreement is a separate animal. You're like, okay, well, if I've got a compensation agreement, would I use this section? Yes, you're going to use this section. You're going to say, hey, look, buyer, we have an agreement at 3% on my compensation agreement with you. I have a the buyer, okay, let me backtrack. The buyer agency agreement has 3% listed. The seller is willing to do a 2.5 commission agreement with you on a compensation agreement. The buyer is still responsible for the 0.5%, no matter what. Yes, we've discussed that you can go back in the buyer agency agreement and make that adjustment appropriately. But let's just say, hey, the seller still owes me 0.5%. You would actually put 0.5% on here to include the dollar amount of any closing costs that you want them to spend. So in other words, if the buyer wants you to ask for $5,000 in closing costs and you're owed an additional 1,000 under the buyer agency agreement, then you would put 6,000 here. So 5,000 towards the buyer's closing costs and 1,000 towards your additional compensation that the buyer owes you, but we were asking it for the seller. I hope I can make that as easy as possible. I know it gets a little more complicated in these things, but you would put 0.5% on there if you're short, according to the buyer agency agreement. Now, we have two options under this. So we're asking for $6,000 in buyer's transaction cost here, as an example. Option A says that the seller agrees to pay blank dollar amount of this transaction cost to be paid by the seller to go towards buyer compensation fee. So what you're going to put on there is $6,000. And it says that this concession cannot go solely towards buyer compensation if listed on the MLS. Listen, this is such a pet peeve of mine. It says cannot solely go towards to pay brokerage compensation if the concession was advertised on the MLS. I can't even tell you because our MLS clearly says seller compensation, yes or no. So I'm not sure. I think I was a real big stickler for ensuring that we just added $1 to that second line so that if we ask for $6,000 up here, I wish this was all in the same section. If we ask for $6,000 right here, oops, right here, I don't know why it's not highlighting, then we would ask for 6,001 here just to protect our ass. I don't know if they made that any clearer or not, but if you're asking for a commission, any part of this transaction cost going towards your commission, just do that first line, 64A. That's going to be your best bet, honestly. The second one, option B, which I don't think we're going to do too often, unless you have a fully covered compensation agreement for all of your commissions taken care of, you don't need to ask for any more, then you can do option B, which just says all of the money that we're asking for on the transaction cost concession is all going to go towards the buyer's closing cost. So that's option A and B. I hope that came out clear enough. So one more time, just for fun, 6A4 right here. First line, we're asking for closing costs to go towards buyer's fees. That's item section 1. How much money are you asking for the seller to pay for the buyer's closing costs? Option A under that is how much of that money that you're asking for is going to go towards the buyer's agent commission. And if none of it's going towards buyer agency commission, then you would do section B. I guess that was a little bit easier, clearer. Sometimes I want to say more than I want to say, and then I get confused. So thanks for bearing with me. All right. It does say under the rest of that particular section that the buyer is responsible for any buyer transaction cost that exceeds this amount. So the buyer still needs to pay the difference. If the amount exceeds the actual amount cost associated by the lender, then any excess funds will revert to the seller. Very rarely do we have excess funds. The buyer is responsible for the buyer's transaction costs, and the seller is still responsible for the seller's transaction costs. So that hasn't changed. It's just a matter of having a credit from the seller or not. If you see in this bold area, it says that the HOA dues and assessment are not considered transaction costs and are addressed by the closing attorney as needed under paragraph 21, was 21. A transfer fee is a non-recurring fee that will be assessed solely because of the transfer of the property of the ownership. Again, all of that will be done under adjustments, just like property taxes. So depending on what day you close, all of that's going to be prorated. You guys are going to be fine. So you don't need to worry about addressing that particular issue and who's going to pay for that. Now the next section does talk about the HOA assessments and what is non-reoccurring, what is unexpected, what is non-budgeted, who's going to pay for these special assessments that are a part of the deal. You don't know sometimes if there are any special assessments, quite frankly, until a little bit, closer to closing. Sometimes they sneak up on you. Sometimes they just shock you. So here you need to figure out if the special assessments are going to be approved prior to closing, will be the responsibility of the seller, or if they're going to prorate and be responsible for a portion of it, fully responsible or a portion of it. So make sure you choose wisely on that. And if you're a listing agent, make sure you choose wisely when you respond to a counteroffer, because you may not want your sellers to be fully responsible for that assessment. Finance section number 7. Y'all already know this section. Is it contingent or non-contingent on financing? Always make it contingent on financing. What kind of loan is it? Is it going to be a 30-year, a 15-year, or other? Is it going to be an ARM? You need to mark that in there. What is the loan to value percentage? Remember, if they're putting down 3%, the percentage is going to be 97 here. For years, a lot of people still had issues with that. It's pretty clear on how you're supposed to do this. If it's 100% financed, you could put 100% there. If you're putting 10% down, then it's going to be a 90% loan to value loan. So make sure you know how to fill that out. If you don't know how to fill that out, that's what lenders are for. Lenders will be more than happy to help you kind of figure out what the client's going to do. Goes on to talk about how there's a finance contingency. It expires at closing. If your clients are denied financing anytime during the contract, your clients have the right to get out of the contract without paying the due diligence fee, the termination fee, because financing is completely separate than that due diligence contingency or the termination fee time frame. The buyer must make good timely efforts to apply for the loan. The buyer's lender to disclose any information to the seller. So here it clearly says that the buyer's lender has the right to answer the questions from a listing broker or their sellers, mostly listing brokers. Sellers are not going to call your lender, but we're just letting the buyers know, hey, listen, the listing agent can call and get updates, which is a really big deal. The buyer shall apply for financing by X amount of date. Sweet baby Jesus, I hope your clients have already applied for financing prior to showing property. Otherwise, you've just wasted your time. Sometimes. Shall deliver notice to seller of reasonable pre-final loan approval. I love these words because they really don't mean anything. And it goes into all of this. Must notify the seller in writing within X amount of days if they are not approved or if they're denied. the seller and brokers as soon as possible. If the seller and brokers are notified of the inability to obtain financing during the finance period, either party may terminate this contract by notice. The lender name that your clients are using would go here. It may change. It says may change. Back in the day, we used to have to line through and change it when we changed lenders. Here, we're just notifying that the lender's name may change. Is it going to be an FHA, VA, conventional, or seller financing? Um, a FHA, VA financing addendum is or not attached. Traditionally, we do not attach them. We do have SCAR forms that will allow you to mark this and attach it. But if you do that, sometimes it's a waste of time because the lender is going to send you their own version of what they have for FHA or VA addendum. All right, Section 8, moving on to due diligence. I love this stuff. So due diligence. The buyer has the right to terminate for any reason whatsoever. What does that mean? The due diligence time frame is for your client to be able to utilize and look at all things that are very important to them during this time frame. Get all your inspections done. Everything needs to be done in this time frame except for the following, which we explain. So how long do you want your due diligence to be? It depends on when you guys plan on closing. If it's a 30-day closing, due diligence can usually be a week. And it's at 6 p.m. So with due diligence, it ends at 6 p.m. That means that on that day that is explained in this section right here, you better have your notice of termination and your termination fee paid for to the seller by 6 p.m. that night, or you are stuck in an as-is contract. There's no way around it. There's no what ifs. This is what it is. By 6 p.m., you better have your shit done if your clients want to terminate the contract. During the due diligence period, the buyer may conduct any and all inspections that they wish and may, in a timely, terminate for any reason at all whatsoever. We spelled this out. Like, again, I don't know if we wrote this contract because people weren't understanding what all of these things mean, but here we clearly identify that the buyer can get out. We don't have to tell them why we're getting out. We can just send them a notice of termination, pay the termination fee, and get out. No explanation is actually necessary, but we do tend to tell sellers why we get out. Termination fee. Should the buyer terminate during the due diligence period for due diligence reasons, they will pay a termination fee of X amount of dollars, which goes right there. How much are you recommending that your clients submit for termination fee? Whatever you can get away with when you're submitting an offer. We typically see $100, $200. We've seen $500 start to become a little more commonplace. As a listing agent, you want that fee to be as high as possible so that the buyers have more skin in the game, but you don't want to scare away buyers right now. So, this is going to fluctuate on what the average is depending on the type of market that we're in, as you guys all know. So right now, a couple $100, normal. Next section, should the buyer terminate under a different contractual contingency? This is like, hey, listing agent, I don't owe you shit. I do not owe you any termination fee if we are terminating because of these following reasons: finance, appraisal, CL 100, sale of the buyer property. It says it in bold that we do not owe them a termination fee. A termination fee will not be owed if we are exercising any of these contingencies. If there's a CL 100, the seller's not making repairs, we can terminate. We don't owe you a termination fee. The appraisal comes in low and we try to negotiate and the negotiations don't go well and we can't come to a meeting of the minds, we can terminate and not owe you a termination fee. This in conjunction with the Carolina Elite clause that says that if the buyer and seller can't agree to repairs, then the buyer does not have to pay the termination fee. This is in conjunction with that. So between this and that, it's like not a lot of termination fees due, except for the fact that your client probably found another home and they just want to go ahead and cancel their original offer and go submit on another one. That's where they would probably pay the termination fee commonly. So we do explain it for all the silly people out there who have fought with me as a broker in charge and said, no. They're terminating during the due diligence time frame. I don't care if it's because of the finance contingency they owe us termination fee. We do not owe the termination fee. Please utilize this part of the contract to argue with other agents when they try to argue with you. By the end of the due diligence period, the buyer must either accept the property in the as-is condition, negotiate or repairs using the 525. Make sure you understand this part right here. It says both buyer and seller are agreeing to the terms of the repair request prior to due diligence time frame. You must put in your repair request and have it ratified prior to the end of your due diligence time frame for those repairs, okay? The 525 is your repair request. Do not say see home warranty. Spell out every single repair your clients want on that 525, that repair request. And make sure you are very conscious of what you say repair or replace. That's a big deal on what you want the sellers to do. Do you want them to repair something or do you want them to replace something? Do not put a slash. Pick one. That's a 525. Parties agree to other remedies. Maybe we decide to do $5,000 in lieu of repairs. Make sure you have an addendum that states that. Or during due diligence, if you cannot agree on repairs, then you can do a notice of termination form on there. In bold on the bottom of page 3, it says failure of the buyer to do option 2, 3, or 4 during the due diligence time frame, then you are now currently stuck in an as-is contract. So termination fee, notice of termination, or ratified repair requests all by the end of the due diligence time frame, or your clients will be stuck in an as-is contract, which goes on and explains that there will be no repairs or replacements at all on the home, and you're still contractually bound to purchase the home. Number 9 discusses inspections or reinspection rights. It says you must have a licensed and insured inspector reasonably perform a non-destructive examination. Like we can help if a home inspector damages a home, but it does say a non-destructive examination, making reasonable record of property with notice to seller of closing for any investigations off-site conditions. It just says that the buyer and the persons that they choose may make reasonable visual observations of the property. The next section in bold says that the sellers will make the property accessible for inspection and not unreasonably withhold access so that your clients and inspectors can get in the property. It says we also have the right to do a final walkthrough of that property within 48 hours of the closing date. They cannot deny you. Also states that the seller will maintain and keep all utilities operational up until the day of closing unless otherwise agreed. Then we go into some hold harmless stuff in that next section about us or the inspectors, which we don't cover inspectors under the law, but it just says, hey, you can't sue us if something happens because you hired the inspector and he's an asshole. Appraised value, number 10, 2 blocks. Either it is contingent on the home inspection or on the home appraisal or it's not. I always state whether you plan on doing an appraisal or not, I always make a property contingent on appraisal. I would say 99% of the time we have sellers or buyers who say, I don't care what the appraised value is. And then maybe a week before closing say, I really want an appraisal value. I was looking at some of the comps myself online and I don't like the way that looks. I want to do an appraisal. And then the appraisal comes at $100,000 less. There's nothing they can do about it. So try to always make a contingent on appraisal. Whether your buyer chooses to exercise that or not is totally up to them. But I like to leave it as an option. You can tell that I was born and raised as a buyer's agent. I can never do the sellers. The sellers and I never really got along. I did my listings, but I really like sellers or buyers more. That's just the way I train as well. So number 10, again, appraised value. Is it contingent or not? Make sure you give them 5 calendar days to be aware that the appraised value came in lower, and then you guys can negotiate or purchase as is or make up the difference or proceed however your buyers want to proceed. Item 11 is the CL 100 wood infestation report. And if the property has been sold previously or previously occupied, that this contract is contingent or is not contingent. Pay attention to these blocks. They're all lumped in right here, so you guys kind of skip over some really important blocks. I will tell you from experience that CL 100s and termites, spoken as somebody who knows more than you guys even realize I know, considering the Park Circle loss that we recently had. Make sure you pay attention to all this stuff because lawsuits can come into play, and this is super important. So is the contract contingent or not contingent on CL 100? upon the buyer or seller having the property inspected at their expense. Who is paying for it? So the first set of blocks, buyer or seller, who's paying for it? Next block. Okay, well, if that person's paying for it, who is selecting the person doing the CL 100s? Who's picking the company? So contingent, not contingent. Who is paying for it? And then who's selecting the company? Typically, whoever pays for it is who is selecting it, but that is totally your guys' call, your client's call. After that, the next block, which is back to back, who's going to provide the reports of the CL 100s? So typically, whoever is paying for it, whoever is ordering it, is also the person who is responsible for getting the copy to all parties, okay? Make sure you know that CL 100s are only good for 30 days prior to closing. So when will the CL 100 be completed? Is anywhere between that 30 days and closing. How many days prior to closing will the report be sent? Make sure you are aware of this time frame. So no later than 14 calendar days, 11 calendar days before closing. You got to make sure all parties have enough time to review the CL 100 and to make the necessary repairs. So when you say, hey, the report's going to be delivered on this day, make sure you guys are aware of what day it's going to be prior to closing. Okay. It talks about what the requirements are for the CL 100. If the CL 100 comes back with being positive for having a termite infestation or other wood destroying organisms, the seller shall remedy these deficiencies and provide the buyer with a fresh, clean CL 100 report that says that everything is all cleared and has been remedied. If they choose not to do that, then the buyer has the right to negotiate the repairs. Maybe they can do money in lieu of CL 100 repairs, or they have the right to terminate. If the seller does not make the repairs, the buyer has the right to terminate. CL 100 is required under South Carolina law to be met as far as contractual purposes. All right, item 12 talks about that, hey, we recommend that you have the property surveyed, title examined, to make sure that the elevation is taken care of. Something I do want to mention, especially recently, is the flood insurance or hazard or liability or homeowner's insurance. Listen, before your clients get too deep into the due diligence and before it expires, I always highly recommend that they look to ensure that the property does not currently have flood insurance and to also get a quote on what the flood and or homeowner's insurance premium will be on this property prior to due diligence ending. These can be big deals when it comes to closing on these properties, especially with our insurance that we have with some of our binders recently coming in a little high. I always tell the clients, make sure you look at different homeowner insurance policies during due diligence. That way there's no surprises at the end. Don't wait till the last minute. Get those quotes in, okay? 13, any item that's listed on the contract will be observed, kept, or performed after closing. It survives the contract. So even if the contract closes or is terminated, if there's something outstanding that's listed on this contract, it will supersede this contract being expired. Casualty or fire, if the property is damaged in a fire or a hurricane, the the buyer can submit a notice of termination on this. Number 15, property disclosure. The South Carolina property disclosure form, the 4 pages that will get every seller sued if they lie. We'll also get an agent sued if they fill it out for the seller. This is a document that the seller must fill out. It says that the buyer and seller agree that they will submit one or they will not. Those are the only 2 options. Honestly, your clients better be reviewing the South Carolina seller's disclosure that's located on MLS prior to submitting an offer so that your clients understand what kind of house they're submitting an offer on. So make sure you review that seller's disclosure prior to offer. And if there's not one uploaded, make sure your clients understand the legality of not having one loaded on the seller side, that you will minimize their amount of liability. So make sure it is or is not. Number 16, lead-based paint addendum. Make sure that if the home was created prior to 1978, that you have a lead-based paint addendum signed by all parties. An update on number 17 is the sex offender or criminal information. They did update to understand that all parties, which mean buyer and seller, agree that brokers are not responsible for obtaining or disclosing any information in the South Carolina Sex Offender Registry. We have nothing to do with it. We're not going to tell you one way or the other. We have nothing to do with the Megan's Law. That is something that the buyers need to make sure they research prior to submitting an offer and or during their due diligence time frame if that is a big deal for them. I mean, it's a big deal for all of us, but just saying. We do not disclose that information and we're not responsible to do that either. Trust account doesn't really apply to us. We do not hold earnest money. As far as like the attorneys, I don't know if they are interest bearing or not. Majority of them are not interest bearing. Again, you would say may or may not. It's kind of irrelevant at this point. Income tax and out of states. My biggest thing is what I tell them in this section is like that you're going to contact your qualified tax advisor to see if you're going to have any tax issues once you have federal income tax for selling your property. Item 20, entering into a binding agreement. Both parties understand that by signing, dating, and initialing, all the changes, that they are actually in a legally binding contract. Number 21 is adjustments. This is where we discuss all the fees that are reoccurring that need to be prorated at closing, which the attorney will do depending on what the closing date is. The seller is responsible for this amount. The buyer is responsible for this amount. All these fees have been prorated. Item 21 actually just kind of lists all the items that would be prorated. So that way, if your buyer has a question, like what items are going to be prorated, what's the seller responsible for? He was there for 6 months. I was there for 6 months. How much does he pay? That is all going to be prorated on the closing settlement statement. By the closing attorney. So you can go through this list with them so they understand what will be assessed and prorated. Number 22 talks about default. This is what the seller needs to do. If the seller defaults, this is what's going to happen. And then also goes into if the buyer defaults, what the buyer needs to do and what happens if the buyer defaults. So these are just very rough legalities that we have to go over in the contract so everybody understands that they should not default on the contract. Item 23 is a non-reliance clause. It says, hey, you guys understand that you got into this contract freely and voluntarily without listening to anything that I promised you. I did not promise you that your home's going to increase 50%. I did not promise you that you're going to have no 526 extension through your house. There was nothing that I said that persuaded you or confirmed that you were going to buy this house because of something that I said. So non-reliance, you're not relying on anything that I said to purchase this property. You are doing it solely based on the fact that you want to purchase this property on your own. That's literally what number 23 says. Broker disclaimer, again, to go with trying to cover our ass in the real estate world, we discussed that the parties acknowledge that the brokers give no warranties or representations of any kind, expressed or implied. In other words, brokers do not know anything about the condition of the property. We don't know anything about termites, radon, mold, asbestos, moisture. We don't know any of that. We don't know about the offsite conditions. We don't know if there's going to be a landfill in 10 years next door to your property. We don't know that. We don't know what the condition of the property is going to be. We can't look at a lot and understand what the survey is going to say. We don't know anything about the easements or encroachments. We don't know anything about the schools. It just goes on to saying, hey, I don't know, listen, I'm telling you to hire the professionals to look into this stuff. I'm here to help you look into this stuff, but I'm not here to tell you what I think is 100% accurate. So that's basically what broker disclaimer means. Item 25, broker compensation. With broker compensation, I have a few notes here, and it says parties direct closing attorney to use settlement funds to collect and disperse compensation to brokers in accordance to this agreement in any separate listing or buyer agency agreement. So in other words, we're saying, hey, attorney, you can disperse these funds, and we want you to disperse them in accordance to what the listing agreement or the buyer agreement says, or a compensation agreement. We've had this weird scenario lately where we've had closing attorneys demand our buyer agency agreement. It's kind of interesting that that is being requested because the compensation is totally usually on either this contract or it's on a compensation agreement. The need for a buyer agency agreement or a listing agreement is completely irrelevant if we have other documents that state what the compensation is. So I'm not quite sure where we're going to go from there, but just be aware it's not required to be submitted because we've got a compensation agreement. So back to item 25, broker compensation. Parties agree to direct the closing attorney to disperse the compensation. It does say, please note, if the compensation of any broker is to be included in this agreement, the parties should attach the buyer broker compensation agreement or the appropriate SCR Form 110 or similar agreement in this agreement to reflect the same. Parties agree that brokers are third-party beneficiaries to this contract and have been standing to seek remedies of equity. So in other words, if they do not pay according to the contract, we have the right to sue, and that's how we're going to get paid. Parties represent that only their enforceable agency or non-agency agreements are going to be disclosed within this contract. Again, big dilemma on how to move forward. But if you have a compensation agreement or your compensation agreement is under 6.4a, then that's what they can use to disperse. Item 26 discusses items that should be attached. I just had a discussion with another agent in the office today, and she felt that this was completely excessive. For me, I think I kind of love it. It keeps me from having to write out in those little 3 lines that we used to have all the different attachments at the time. You don't have to click all of these. Just check mark the ones that you currently have attached. Odds are you're going to have a compensation agreement, either 1 or 2 on here. You're probably going to have this one here, an addendum, the SCA Form 390, which is just a blank addendum that you needed to add. You're going to probably have a home warranty addendum and a wire fraud warning. Quite frankly, we're not going to utilize all of these, but it keeps us from taking the time to have to write out all of these items by hand on the 3 lines that we previously had with small, tiny line space. So I love it. I think it's great. They do try to do a good job of things that you would use most commonly in a contract. So just check, check, check. Great. And the reason why that's important is because remember, if you're using this video as a refresher course on how to do the contract, sometimes attachments can go missing if they're not referenced on the main contract. So just try to remember that, okay? Number 27, notice and delivery. Notice is a unilateral communication, offers, counteroffers, acceptance, termination. Please make sure everything's done in writing. Make sure you get confirmation when you send something to the other party that is confirmed received to abide by delivery. Acknowledgements. This is kind of a generic, hey, buyer and seller, be aware of like crazy shit. Let's jam all of the weird, crazy shit that we want to say in a contract in this one little paragraph. So 28 is like your weird paragraph. It says, due to potential criminal activity, parties are solely responsible for verifying all wiring instructions with a law firm or bank. This is why we have our wiring fraud alert on the bottom of our emails, and why we also have the wiring fraud addendum attached to the contract to let the clients know, listen, wiring instructions never change. So don't fall for anything. In this paragraph, we also state that parties are also advised to understand that audio and visual surveillance may occur in the property, and parties should plan accordingly and keep your mouth shut. It says if you're like looking at a property or viewing a property, and we are in that property, whether it be at the time of like looking at it during showing, if it happens to be a home inspection, if it happens to be final walkthrough, be aware that audiovisual will probably be taking place in that home. And South Carolina is a one-party state, so they do not have to notify you if they have audio or video surveillance on you in that property. So just make sure whenever you review this contract with your clients, hopefully you review that aspect of this prior to going into listings, that they need to be aware, hey, they may be surveillance in that property. So shh. Also in here, it says parties acknowledge the receiving, reading, reviewing, and understanding this contract, SCA, or the South Carolina Real Estate Brokers Relationships Form, or any other agency form. Parties acknowledge that they've had the opportunity to review all these documents and receive legal counsel with their attorneys prior to signing this contract. Like, hey, you can't say, I didn't read it. You had the opportunity to take it to an attorney or review it at your leisure. Oh my God. Item 29. You guys are killing me. Item 29, expiration of offer. Expiration of offer. No one is filling this out anymore. Fill this out. Fill this out. Item 29 says, when signed by a party and intended as an offer or counteroffer, this document represents an offer to the other party and may be rescinded at any time prior to. And this offer expires at blank time. So what numerical time do you want this offer to expire on what date? So time and date, actual day. Um, and if you do a counter offer, make sure you also do an expiration of offer on the counter offer. So if you're going through this contract and you're making changes on a counter offer, make a change to this section because it's got to expire at some time. And then it says on the bottom, there's a witness. This contract has been duly executed by the parties to the best of their knowledge. Make sure there's nothing that's power of attorney or any other like corporation authorization attached. And if there is an LLC or an estate purchasing this property, make sure you've got those documents, legal documents attached. And then something I want to mention before we finish this one up is SCAR is really coming down hard on this last page. I know this is going to be a big audit issue as well. Buyer and seller signatures, date and time, date and time, date and time. But the most important part is the notice address, email, or fax number, where again, we're spelling things out that's simple and easy for everybody to understand. This section is where the buyer wants all contracts and correspondence to be sent. Honestly, the buyer's agent email address is completely sufficient here. So where do they want all of the counter offers to be sent? The buyer's agent address or email address is perfect right there. The reason why I'm bringing this up is because the next section is the seller section. And it says notice address, email, or fax, where the seller wants all contracts, correspondence, and the termination fee to be sent. Y'all, this is so important. If you are countering and you've got a deal, make sure that the listing agent gets this section filled out because we need to know where they want the termination fee to be sent. Does the sellers have a Venmo? Can you put that on there, please? Do the sellers want Zelle? Do the sellers want me to drop off the termination fee to the listing brokerage office, main office? Listen, this is for your benefit so that you're not scrambling to where to send the termination fee. Meet this head on and figure out what this answer is when you're submitting counter offers and offers, okay? Make sure you get that taken care of. And then, of course, the bottom half, you guys already know, is your particular information with LLR. LLR office code, by the way, is on your real estate license. So I love getting text messages at like midnight on Friday asking what our LLR office code is, even though I do answer 99% of the time. Just know that this code, if you need it and I don't respond, is on your real estate license. That is the real estate contract as of June of 2025. That was fun. I think I'm done now. I'm a little tired and it's been an hour. Actually, I kind of did under an hour. It's 58 minutes. So take care. Let me know if you got any questions. Thank you.